Law. How should charter schools prepare? My name is Elka Sachs, and with me is Judith Kim. We are both members of the charter school practice here at Krikitas and Bluestein. Krikitas and Bluestein has represented charter schools since the first charter schools formed in 1995. We are also honored to represent the Massachusetts Charter Public School Association, today's host. We have a full-service charter school practice, including governance, state ethics, public records, contracting, public procurement, real estate acquisition and development, finance, employment and labor law, special education, and discipline. Our focus today will be the updated public records law. Before Judith and I begin to discuss the updated public records law, I'm going to share a couple of quick notes about the webinar process for those of you who aren't familiar. A copy of our slides will be emailed to you after the presentation. If you have any questions at any point, you can type them into the questions box on your screen at any time during the presentation. We will have plenty of time for Q&A at the end of the presentation. Your questions will only be visible to me and Judith. They are not visible to other webinar participants. Feel free to share your name and school when you ask your question, but if you prefer to remain anonymous, please let us know. Our goal today is to educate charter schools on their responsibilities under the updated public records law. But first, a little background. There appears to be two primary motivations behind the updated public records law. The first motivation appears to be an attempt to bring the law into the modern age. Prior to its recent update, the public records law was last revised in 1973. Email was then in its infancy, and electronic record keeping had not become the norm. The second motivation appears to be an attempt to address a host of complaints regarding the implementation of the existing public records law. In particular, complaints have been made about the long delays in responding to public records requests and the exorbitant fees charged to comply with public records requests. Massachusetts has been ranked low for government transparency, likely as a result of these complaints. Governor Charlie Baker signed the new legislation, an Act to Improve Public Records, on June 3, 2016. The law becomes effective on January 1, 2017, and applies to requests submitted on or after this date. As directed by the updated public records law, the Office of the Secretary of the Commonwealth has issued proposed regulations in order to implement the statute. A public hearing was held in October, and the comment period regarding the updated public records law has ended. Final regulations are expected by January 1, 2017, as required by the updated public records law. Because the final regulations have not yet issued, in this webinar, we will refer to the proposed regulations, recognizing that these might be further revised before they are finalized. This webinar is targeted towards charter schools. We want you to understand how the updated public records law may impact you. We will begin with some basic terminology used in the updated public records law. Specifically, what is a public record and what is an agency? Next, we will discuss the role of a charter school's records access officer under the updated public records law. This is a new position essential for compliance with the new legal requirements. We will explain the new website posting requirements as they will apply to charter schools. After covering the general administrative requirements, we will discuss public records requests under the updated public records law, covering 5 topics: what has changed and what remains the same, the critical timeline of the initial response and records delivery, the content of the initial response, the format of records delivery, and the fees that may be charged under the updated public records law. We will discuss the 3 types of petitions to the supervisor of records that may be made by an agency when faced with a difficult public records request. Last, we will discuss the recourse that a requester may have when the requester feels that it has not received an appropriate response under the updated public records law and the penalties that will be imposed on agencies for noncompliance. Judith, why don't you get us started?
Thank you, Elka. Before Elka and I go into detail about the substantive requirements of the updated public records law, we wanted to start by going over a few basic terms. When we talk about public records in this webinar and the requirements that are imposed on government entities, such as charter schools, regarding their public records, we are including any record that is made or received by a government entity or any of its employees, unless an exemption applies. The updated public records law separates government entities that are subject to the public records law into two groups, agencies and municipalities, and imposes slightly different requirements on each. There is no official guidance on whether charter schools will be treated as agencies or municipalities, but for purposes of this webinar, we assume that charter schools will be treated as agencies, and therefore will be discussing the requirements imposed on agencies throughout this presentation. First, I'm going to cover the requirements regarding the records access officers under the updated public records law. A charter school will be required to appoint at least one of its employees to serve as a records access officer who has certain responsibilities under the updated law, which I'll be covering in the next few slides. Under the proposed regulations, the appointed records access officer can designate one or more secondary records access officers to assist in its responsibilities. The proposed regulations also require the Public Records Division to be notified when a records access officer and any secondary records access officer are appointed or changed. The contact information of each records access officer must be posted on the school's website, including his or her name, job title, phone number, and email address. The records access officer has specific responsibilities under the updated public records law. The records access officer's primary responsibilities will be to coordinate responding to any public records requests made to his or her school, to assist any public records requester in identifying the records that he or she is looking for, and to prepare guidelines that will enable a requester in making an informed request. The proposed regulations require these guidelines to include a list of categories of public records that the school maintains. The records access officer will also be responsible for posting the documents that are required to be posted online under the updated law, which I will go into more detail a little later. In addition to being responsible for coordinating the response to each public records request, the records access officer will also be responsible for documenting specifics regarding each public records request that the school receives. This slide lists all of the information that is required to be kept by the records access officer, including the nature of the request, when the school received the request, and the school's response to the request. The records access officer will be responsible for submitting an annual report to the Public Records Division by the end of each calendar year with the information that was listed on the previous slide. The template for this annual report is expected to be released by the beginning of next year. Last, the records access officer will also be responsible for assisting his or her school in preserving its public records. As I mentioned earlier, the updated public records law requires each agency to post certain materials online. Each charter school must post its annual reports, winning bids of public contracts, awards of any government grants, minutes from all open meetings, and its budgets on a searchable website. Additionally, as I mentioned earlier, the guidelines prepared by the records access officer to assist requesters in making informed public records requests, as well as the contact information for each records access officer must be posted on the school's website. I have just provided a summary of the requirements regarding the records access officer and what information needs to be posted online. I am now going to turn it over to Elka, who will discuss the requirements that have changed and have not changed under the updated public records law, as well as how a charter school must respond to any public records request received on or after January 1st of next year. Elka?
Thank you, Judith. Well, the key significance of the updated public records law is, of course, the handling of public records requests. Charter schools are long familiar with public records requests and need to understand what has changed and what remains the same under the updated public records law. In particular, the updated public records law imposes new requirements with respect to the content of initial responses, the format of records delivery, and the fees that may be changed, as well as the timeline for responses. So we start with what has not changed. First, what has not changed? Well, the general obligation of charter schools under the public records law has not changed. As public agencies, charter schools are required to maintain public records, respond to each public records request, provide a requested public record unless an exemption applies, charge a reasonable fee. In addition, minimal changes have been made to the public records exemptions to the obligation to provide public records, meaning that the public records requesters are not entitled to receive documents or portions of documents that are exempt from the public records law. A couple of exemptions are particularly relevant to charter schools. These include disclosures prohibited under applicable law, such as FERPA, which prohibits the disclosure of student records. A second example is the disclosure of personnel and medical records, exemptions that are outlined in the statute and interpreted under case law. The updated public records law makes no change to the way in which this exemption is defined in the statute, nor that case law interpretation. A third example is the disclosure of information that is considered an unwarranted invasion of personal privacy. The updated public records law makes no change to the way this exemption is defined in statute, nor the case law interpretation. What has changed? Well, a number of important changes have been made. One key change is the required timeline. The new timeline is measured in business days rather than calendar days, which sounds like it provides some additional breathing room for charter schools. However, as we shall see, there is much greater specificity in the required timeline. There is also much greater specificity in the updated public records law about the component elements of a required response. A key change is that the production of records in electronic format is now required unless the requester prefers a different format. There are new penalties for failure to meet the required timeline. The fees charged by the school are now much more limited. Finally, attorney's fees may be awarded to a requester in court upon appeal. Deemed receipt. Well, the updated public records law now includes a new standard for establishing the date of receipt. If the request for records is made orally, the request is deemed to have been received when made. If the request for public records is made in writing, it is deemed to have been received on the first business day following electronic transmission or physical receipt. The timeline for both providing the initial written response and the production of records has become more restrictive. The initial response must be provided within 10 business days, not 10 calendar days. That's helpful to the schools. However, the production of records must also be made within that timeline. And there are new penalties for failure to respond in time. There are 3 permissible responses to a request for records. A charter school may provide the requested records. That's easy. Alternatively, the charter school may provide an itemized good faith fee estimate, Finally, the charter school may provide a denial based on one of three permitted grounds. Option 1 applies if the charter school does not possess the record. If that is the case, the charter school must explain the ground for denial and identify the agency or municipality that might have the record. A second permitted basis for a denial is that an exemption to the public records law applies. If that is the case, the charter school must identify the specific exemption or common law privilege. If the charter school is claiming attorney-client privilege, the charter school must include the names of the author of the record and the recipients, the date of the record, the substance of the record, and the grounds upon which attorney-client privilege is claimed in the response to the requester. The third permitted basis for a denial is that the request is unduly burdensome. If that is the case, the charter school must explain in detail why the request is unduly burdensome, identify a reasonable timeline no later than 15 business days following receipt of the request, and suggest a reasonable modification to permit efficient production of the record. Any denial of a public records request must also include the date of the request, must identify the records or categories of records that will be produced, must include an itemized good faith estimate of any fees that may be charged, and must include a statement that the requester has the right to appeal administratively to the supervisor of records and the right to seek judicial review of an unfavorable decision from Superior Court. There are new requirements for the format of records delivery in response to a public records request. A requester is entitled to inspect and/or photograph or scan records upon request. The requester is also entitled to receive records, whether in person, by mail, by fax, or electronically. The updated public records law assumes that delivery of records in machine-readable electronic form is preferred unless unavailable. The updated public records law requires agencies, such as charter schools, to ensure that any new record-keeping systems that they acquire allow for electronic access and maximum public access to the extent feasible. There are several new restrictions on the fees that may be charged to comply for a public records request. In general, a reasonable fee may be charged, which does not exceed actual cost. However, the charge for copies is limited to 5 cents per page, and electronic or faxed copies must be provided for free. As discussed earlier, records must be provided electronically unless the requester asks for another form of delivery. A charter school may not charge for redacting records unless redaction is required by law or approved by the supervisor of records. The charter school may only charge the hourly rate of the lowest paid person capable of performing the task up to a maximum of $25 per hour. No charge at all may be made for the first 4 hours of labor. A charter school may charge for actual postage if the requester asks for a record to be mailed or cannot receive the record in person. However, understand the requester may ask for the lowest cost mailing available. Well, Judith, I'm going to turn the presentation back to you.
Thanks, Elka. I will now be discussing the types of petitions that a charter school may make to the supervisor of records, as well as the types of petitions and appeals that a requester can make under the updated public records law. A school can petition the supervisor of records for 3 reasons: to charge for time spent redacting when redaction is not required by law, to request an extension of the deadline of up to 20 business days to produce the requested public records, and to request a longer extension or even a waiver from the obligation to produce the requested public records under certain limited circumstances. In order for a school to request charging for time spent redacting when the redaction is not legally required, the request must be for a commercial purpose, or the request cannot be prudently completed without the redaction, and the fee estimate represents an actual and good faith representation by the school to comply with the request. It is important to note that the supervisor of records is legally required to consider the public interest in limiting public access, the financial ability of the requester, and other relevant extenuating circumstances in making the decision on whether to allow the school to charge for this type of redaction. Like Elka mentioned earlier, a charter school may have up to 15 business days to produce the requested public records if the request is unduly burdensome and the school provided an initial response within 10 business days. If a school needs more time to produce the requested records, a school can request an extension of up to 20 business days if two requirements are met. First, the request must be unduly burdensome, and the school must not be able to provide all of the requested public records within 15 business days due to the magnitude of the request or due to the requester submitting multiple requests. Second, the school must show good cause for this extension, such as the need to search for, collect, or segregate records, the amount of redaction that is required by law, the capacity or the normal business hours of operation of a school to produce the requested public records, and or whether the request is frivolous or is intended to harass or intimidate. The supervisor of records is required to consider whether the public interest will be served by requiring earlier disclosure in deciding whether an extension should be granted. Last, a charter school may request a longer extension or even a waiver from the requirement to produce the requested public records if the request is part of a series of requests that are frivolous or are designed to intimidate or harass, and the requests are not intended to disseminate information to the public about government activity. In order for a school to make any of the requests that we just discussed, it must submit a written petition to the supervisor of records within 20 business days after receiving the initial request. However, this does not change the fact that initial response is still required to be provided within 10 business days of receiving the request. If a charter school wants to request additional time, the proposed regulations also require a school to include an explanation of why additional time is needed in this petition. The school will be required to provide a copy of this petition also to the requester, and the supervisor of records is required to provide a written determination within 5 business days. A copy of this determination will be provided both to the petitioning school and to the requester. A requester may also petition the supervisor of records. Under the proposed regulations, the requester must petition in writing within 90 calendar days of a response from a records access officer if he or she is appealing the particular response, or within 90 calendar days of the request if he or she is appealing the records access officer's failure to respond. The supervisor of records is required to make a written determination within 10 business days and may also notify the Attorney General's office to ensure compliance with the updated public records law. The requester may also file suit in Superior Court, regardless of whether he or she has first petitioned the supervisor of records. There are fairly steep penalties for failure to comply with the updated public records law. First, a charter school will not be allowed to charge fees for producing the requested public records if it fails to respond within 10 business days of receiving the request. If a requester files suit and wins in Superior Court, there is a presumption of awarding the requester's attorney's fees and costs. If attorney's fees and costs are awarded, the school will automatically not be allowed to charge fees for producing the records. However, even if attorney fees and costs are not awarded, fees to produce the records may still be required to be waived. The Attorney General's office may also file suit in court against a charter school for failure to comply with the public records law, and if the office wins, the school will automatically not be allowed to charge fees to produce the requested public records. And last but not least, a charter school may also be required to pay punitive damages if the requester proves in court that the school did not act in good faith. Elka?
Well, this concludes the substantive portion of our presentation. We are aware that further guidance on the updated public records law is required, and know that the Public Records Division is aware of this need as well. First, the Public Records Division has said that the final regulations will be issued by December 16th, and that it is not willing to respond to any questions regarding the proposed regulations at this time. This suggests that there might be a difference between the proposed regulations and the final regulations. We have been told by the Public Records Division that an updated guide to the public records law is in process. The existing guide has been very helpful, and we are hopeful that the updated guide will be as well. A third potential source of guidance is advisory opinions that the Public Records Division might choose to provide, or, less formally, over-the-phone advice. There are several areas where we believe future guidance is required. First, as we mentioned earlier, whether charter schools will be considered agencies, as assumed by this presentation, or subject to the somewhat more lenient rules applicable to municipalities, like public school districts. Charter schools, a second issue, will only be able to charge for redaction required by law. While it is clear that redactions required by FERPA of student record information are required by law, the full breadth of this exemption is not clear. For example, Massachusetts has enacted a privacy statute. To what extent does this statute permit charter schools to charge for redaction of personnel and medical records? Another example, charter schools are also subject to public procurement requirements. Further guidance is needed as to the extent to which this allows them to charge for redaction of records relating to sealed bids. Yet another area where further guidance is required. Under current law, a charter school was not required to prepare a response until payment was made. This might well be true under the updated public records law. However, it is not clear how the timetable for producing a response will be impacted by a delay in payment. For example, a simple reading of the updated public records law and proposed regulations suggests that if payment is made on the 10th business day, the charter school must also deliver the records on the 10th business day. As a practical matter, this might require the charter school to begin preparing the response immediately upon receipt of the request, whether or not payment was made, although delivery could be withheld until payment is made. Furthermore, there is absolutely no guidance as to the timetable for delivery if payment is made after the 10th business day. We know that you might well have questions about the updated public records law. We will try to answer those that we can, and if we can't, we will try to get in touch with the Public Records Division to see what response they might have. Okay, so we do have some questions here. The first one is a charter school required to have a specific approved policy with regards to public records law or management? Well, the answer to that is no. There's nothing specific in the statute that requires you to have a policy. However, as we mentioned earlier, the charter school must post guidelines on its website that will assist requesters in public records requests. This is a good question. How far back do we have to post those items on the website? For example, what years of our annual report do we need to post? And I'm going to say the statute does not provide a clear answer. The statute clearly states that it only applies to public records requests made on or after the effective date, but really doesn't talk about the posting requirement. So that's one I think we're going to try to get additional guidance from the Public Records Division. Next question, can a school require the public record requester to make the request in writing? I'm going to say the answer is clearly no. The statute clearly requires the oral, or discusses the oral request, and in fact, the oral request is deemed to have been received when made, whereas a written request is deemed to be received on the next business day. All right, next note. Is it worth noting that a school needs to make sure the duties of a records access officer are covered, sorry, can we scroll up a little? Are covered during school vacations and summer breaks. It is absolutely worth noting that 10 business days does not mean 10 school days. One of the, I think, points that Judith had mentioned is that there's a primary records access officer, and there may also be secondary records access officers. We encourage schools to have the primary and the secondary, not to just rely on a single person to have access to records, because schools are going to need to jump on public records requests immediately. Okay, next question. Is a school required to compile records that exist in separate documents, i.e. salary data? In other words, should we create new records to comply? The answer is no. But if a school receives a request for salary data that's located in multiple records, the school may need to provide the multiple records, even if it would be simpler to provide this single record. In that situation, while the school is not required to compile the records into a single document, the school itself might find it useful to do so, and that becomes the choice of the school. But you should get the records requesters buy-in for that form of delivery, since at that point one's not delivering an actual public record. All right, who is usually the recommended records access officer? I can't answer that one because we've never had records access officers before. But what I would suggest is that it's somebody who's a responsible person, able to turn around public records requests in a very timely manner. What I suspect is schools receiving public records requests are likely to have questions that need to be answered right away so that they know how to proceed. And so you need to have somebody who can identify issues of concern and act on it. What is the contact information for the supervisor of records? I don't have that off the top of my head. We can distribute that. Really, that's the Public Records Division of the Secretary of the Commonwealth, the individual who is responsible there. Can we talk more about the public bid documents requirements? Do we have to post the awarded contract? That is a good question, and I'm not sure. You have to, I mean, the statute says you have to post the winning bid. So I'm not sure that you have to post the contract. My judgment would be no. But we can also follow up with the Public Records Division and see if they're willing to provide a response. Do we have to provide names and birth date, or can we simply provide job position and salary? If they ask for Social Security numbers or home address, do we have to publish it? We are trying to protect the privacy of the employees. So I'm going to go on a limb here and suggest that you're talking about a records request for salary information. And the answer is that you definitely have to provide the name and salary because there's Massachusetts case law which says that's public record. And a job position would fall into that category as well. Social Security numbers are clearly protected by the Massachusetts Data Privacy Statute, so that would very clearly be eligible for the exemption as required by law, and in fact, you can charge for that redaction. That's very clear. As to the question of home address and birth date, so here's where things get a little bit less clear. I would say that under the existing exemptions, you are absolutely entitled to redact. However, that does not necessarily mean that you are entitled to charge for redacting. because it's not entirely clear that that's a redaction required by law. The argument in favor is that information is protected by the Massachusetts privacy statute. However, the privacy statute is really very general, and it's subject to interpretation. Will your office create templates for charter schools, such as guidance documents, examples of reports, etc.? At this time, I'm not sure we have any templates contemplated. The report that goes to the Public Records Division, that's going to be on their form, and I'm sure that they will have that form out within the next month. Or at least I'm hopeful that they will. It's not due until the end of next year, but that is the expectation. As to other types of templates, we haven't really thought about it. I think you're going to find that, at least initially, the responses to public records requests are going to be very individual, very fact-specific, and the petitions made to the supervisor of records will be very fact-specific, and I'm not sure a template is possible. When we are closed for school vacation weeks, do those days count as business days? Yes. Unfortunately, we did discuss this with the Public Records Division already, and business days are business days. And that goes towards why you need to have both the primary and secondary records access officers. You'll need to have somebody who's always available to respond to the public records request when it's received. Requests for commercial purpose was mentioned. Do such requests change the response? So, in fact, yes, you have some more leeway in petitioning the supervisor of records. Interestingly, under the new statute, you are in fact allowed to inquire whether there's a commercial purpose for the records request, which was something that wasn't clear under the prior statute. It is clear that waivers of fees are not expected for commercial purposes. So there's some nuances there.
Right, and just to add to that, Elka,
yes.
We had talked about the three different ways or reasons for which a charter school can petition the supervisor of records. And one of the prerequisites for requesting to charge for time spent redacting when the redaction is not legally required, one of the prerequisites you can satisfy by establishing that the request was made for a commercial purpose.
Will there be a form distributed to schools to submit info to the State Records Department, or are we supposed to inform them of who the officers are on our own? That's a good question. I am not aware that there will be a specific format for notifying the Public Records Division of your records access officer's contact information. I think you're going to need to email that information to them.
That's right.
Without a form. All right, what is the Massachusetts privacy statute, if we wanted to refer to it? Oh, goodness. Actually, it's in the slide. I had put the citation. Let's find that, because I don't know it off the top of my head.
I believe it's Massachusetts General Laws, Chapter 214. I want to say Section 1B.
I think it is. Here it is, 214, Section 1B. And the text of that statute is, a person shall have a right against unreasonable, substantial, or serious interference with his privacy. I don't know that there's a lot of case law interpreting that statute, which is why we're not sure what the boundaries are going to be. I'm aware of one circumstance where there was a violation of the statute found when one party released really personal health care information without consent, which would also violate other laws. Is this webinar recorded? If yes, will we have access to this video for reference? And the answer is yes. I was going to get to this at the very end, but all attendees will receive a link to the presentation, which will permit you to download the PowerPoint. And is that correct, Jack?
Yeah, and we can also, we will be sending out the PowerPoint presentation to everyone who attended today.
Yeah. Okay. All right. Is there another state that has this type of regulation in force already? I don't really know the answer to that, but I did look at some of the literature around the adoption of the updated records law, and my understanding is we were really last on the list, pretty much, on government transparency and surveys. So I'm guessing that most other states, if they don't have legislation that matches the updated public records law, they do have legislation that provided more rights to public records requesters than our current law that was enacted in '73. All right, everyone, thank you very much for attending our presentation on the updated public records law. As I mentioned, attendees will receive a link to the presentation, allowing you to download the PowerPoint. And as always, feel free to get in touch if you have any specific requests about compliance with the updated public records law. We are always happy to help.